So now we will formally start the webinar. So thank you very much for joining us today. This webinar is on protection visa reviews and the Administrative Review Tribunal process. So Hannah's going to introduce herself in a minute. She's going to talk to us about some recent changes. And before I hand over to Hannah, I would like to acknowledge the traditional custodians of the land that we are on today. I am on Camaragal country today, and I pay my respect to elders past and present. Because we do education, this is a webinar for community legal education, I also like to acknowledge that Aboriginal people are the first and ongoing storytellers and educators on this land. So thank you very much for joining us today. And I will now hand over. Oh, sorry, quick. Yeah, we have to do the disclaimer before we start. This information session is a general overview of immigration law concepts. It's not legal advice. Each situation is different. However, we will be telling you how to refer your clients for legal advice, specifically should they need to do that. So we will definitely do that at the end. But yes, this is legal information. So Hannah, welcome and thank you very, very much for joining us today. Can you please introduce yourself? And I think you're going to talk about what you will be covering in the session today. So thanks, Hannah.
Thanks, Natalie. Good afternoon, everyone. My name is Hannah and I work in the immigration team at Legal Aid New South Wales. I'm on Gadigal land and pay my respect to elders past and present and acknowledge that sovereignty was never ceded. I will be talking to you today about protection visa refusals at the new Administrative Review Tribunal. Briefly, I'll talk to you a little bit about what our team at Legal Aid New South Wales does and who we can help. I will talk to you about what type of refusals this session is covering and, importantly, what I don't have time to cover today. I'll talk to you about some important changes with the new Administrative Review Tribunal. We'll talk about applying for review at the ART, the when, what, why, how, who of that. Bridging visas during the review process itself, so waiting for a hearing, preparing for a hearing, and attending a hearing. Briefly, I'll cover what happens after an ART decision, so what someone's options might be after that if they get a negative decision. We'll do a little pop quiz and a couple of case studies. I'll provide you with contact details for our organisation as well as 2 other free legal services based in New South Wales that also can help people who are going through this process. And lastly, we'll have time, hopefully, for some questions. So the immigration team, we're a free service. We advise and represent people on immigration and citizenship matters, largely those that are based in New South Wales. A person does not need to be a citizen or a permanent resident to get legal advice from our service. We largely focus on visa cancellations, citizenship applications for refugees, judicial review, protection visas and some other family stream visas, and family violence, primarily in the context of partner visa applications, but also other visa applications as well. We provide advice and representation at the Department of Home Affairs stage, at the Administrative Review Tribunal, and also at the Federal Circuit and Family Court, the Federal Court, and the High Court of Australia. Today, I will be talking to you about what we call reviewable protection visa decisions. So that refers to decisions mentioned in Part 5 of the Migration Act. And when I say protection visa, I'm referring to a few different types of visa. So that would be the 866 visa, or what people call the permanent protection visa, and then also the TPV, temporary protection visa, the 785 visa, and also the SHEV visa, or the 790 visa. Many of you would have heard these terms thrown around, particularly if you've been working in this area for a while. Those last 2 visas I mentioned, the TPV and the SHEV, are temporary forms of protection visa. I'll talk a bit more about that in a minute, but I'm referring primarily as well in this presentation, 2 decisions where the department has found that a person either does not satisfy the definition of a refugee or they're not owed complementary protection. What is not covered in this session are decisions to refuse a protection visa based on other reasons. So a lot of those might be based on character. So decisions made under Section 501 of the Act or 36(1)(c) of the Act. Decisions might be made that someone can't be granted a protection visa because of an adverse security finding or because the identity provisions aren't met. We're not covering those decisions today. We're also not covering a review of a decision to refuse a different kind of visa other than a protection visa. That's because those decisions, I guess, are different processes and can't all be covered today. But I do believe that on Thursday at lunchtime, IARC, the Immigration Advice and Rights Centre, is running a free webinar about that covers other immigration decisions at the new Administrative Review Tribunal. So I'm sure that will be very helpful for many of you in the audience. Next slide, please. So many of you might have heard about the new Administrative Review Tribunal, or the ART. This replaced the Administrative Appeals Tribunal, or the AAT, late last year in October. With that came new legislation, new practice directions, and some new features. But for your purposes, overall, the new ART has the same overriding purpose and decision-making functions as the AAT. There are a few significant changes that I will go through in a moment. Importantly, if one of your clients has applied for review of a decision to refuse their protection visa application, and they did that when the AAT was still a body that existed, that review application remains valid. They didn't need to do anything to transfer that to the new tribunal, and that review will now just be conducted by the ART. One significant change is that the AAT couldn't review decisions to, well, in most cases, couldn't review decisions to refuse a protection visa application for what we call fast track applicants, or those who arrived by boat in Australia around 2012 and 2013 and were given permission only to apply for a TPV or a CHEV and not a permanent protection visa. Those reviews were conducted, as many of you would know, by the IAA, or the Immigration Assessment Authority. That was actually abolished in October 2024, and those decision-making functions now come within the new ART. So what that means practically for your clients is that any review that was already conducted by the IAA remains valid. But if you have a client, for example, who has since gone to the Federal Circuit and Family Court and they might successfully be able to challenge a protection visa refusal by the IAA, they now have the opportunity to go back to the new ART, the new tribunal now, whereas before they would have just had to go back to the IAA. The IAA notoriously had very high refusal rates, and generally clients were not able to go to a hearing before a decision was made. Very different at the ART, they will have the opportunity to attend a hearing. And so for those clients, this is a very positive change. As well as this, another very important change was made within the last 2 weeks, actually, for people in immigration detention. They previously had only 7 days to apply for review of a protection visa refusal of the kind I'm talking about today. They now have 14 days to apply for review. I'll talk about that again in a moment when I speak about time limits for applications.
Thanks, Hannah. I'm just pausing to see if anyone's got any questions before we go on, to please type those into the chat. Otherwise, Hannah will let you know questions at this stage, but if people think of things as you go, please type those in. And just a tip to remember what Hannah just said about people in detention.
Thanks, Natalie. I just have a few more things to mention about the ART's powers on the previous slide, if you wouldn't mind going back. Thank you. So just briefly, I'll talk about what merits review is. The ART is a body that conducts merits review of decisions usually made by a government department or a government agency. Merits review is a process where a body like the ART engages in what we call de novo or new assessment of a person's application and whether they meet the requirements for grant or approval of that application. So that could be an application for a visa, like what we're talking about today, or it could be an application for access to the NDIS or for supports under the NDIS. It could be an application for a Centrelink payment. The ART will conduct a fresh assessment of this person's application, of their evidence, of their claims. The person will usually have the opportunity to speak to the ART in a hearing, provide new information, new evidence, and additional evidence to support existing claims. This doesn't mean that the tribunal will not consider previous documents and assessments. So for protection visa matters, the member will have reviewed the person's entire protection visa file prior to the hearing with the applicant and may have also reviewed other files for other visa applications that person made. They would have listened to the protection visa interview or interviews that the applicant took part in with the Department of Home Affairs. They would have read any statements or submissions provided to the department and any other relevant documents. These documents are required to be given to the tribunal by the department prior to the hearing being conducted. And I'll briefly touch on that later. However, the important thing about merits review is that the tribunal has the power to collect its own evidence, conduct a hearing with the applicant and make its own new decision. Lastly, the tribunal has powers to remit a decision to the Department of Home Affairs, to affirm a decision of the department, to make directions that are then followed by the department, to dismiss an application for non-appearance or if they don't have jurisdiction, like if an application is submitted after a deadline has passed. And they can also make an order preventing publication of a decision. If your client has mentioned that they might be worried about confidentiality, we can speak to them about how to request this non-publication order. Generally, I will just note that decisions don't ever contain names or other identifying information, but they do often summarize the person's claims for protection and they note the country of reference. So some clients could be concerned that they could be identified through that information. Next slide, please, Natalie.
Thanks, Hannah. Just a couple of questions before we move on. Is there anywhere where people can read about the changes that you've just been talking about?
That's a good question because it can be sort of contained in a few different spots. Sometimes it's in amending legislation or bills that are introduced through Parliament. That can be found on OSLI or on the Parliament, the Federal Parliament website. The ART has some really helpful guides, practice directions. They have a particular part of their website that specifically contains information for people who are not represented throughout the process, so that you might find that really helpful for your clients. Those are probably the best options to try and read about the changes. And we'll probably be preparing at least a brief fact sheet about the changes, and I'm sure some other legal services will be working on that too.
Right. And can you please just quickly repeat the change that you mentioned happened in the last couple of weeks related to people in detention? Yeah.
So that was an amendment to a time limit for people in immigration detention to apply for review of a protection visa refusal. And that's the kind of refusal I'm talking about today. So maybe they were found to not be a refugee. Previously, they only had 7 days to apply for review. They now have 14 days to apply for review.
And a follow-on question, someone's asked if that 14-day time limit, is that enough time generally for the department to give the documents?
For the department
to deliver on, to provide the documents they're required to?
They don't need to do that within that time frame. So within that 14 days, what the person needs to do is make their application for review to the tribunal. Then there's a waiting period before a hearing happens. And so somewhere in that period, the department will provide the file to the tribunal and the client, importantly, will have time to prepare for the hearing.
Great. Yes, I think that clarifies that. Thank you. Okay.
Thanks. Okay, so we'll go through some information now about applying for review at the ART. The first thing I'll talk about is how to do that. So as you can see, I've provided a link here that we can also share afterwards about how to do that online. We'd recommend that applying online is the best way to apply to the ART. There are different forms to use for different kind of applications, even within migration and protection applications. So it's important to ensure that the client is using the right form. We and other legal services can definitely assist people to make this application and ensure they're doing it correctly. The ART has an online system where you can actually have an account, or you can use it as a guest, and it guides you initially by asking you some questions about what kind of decision was made and under what section of the Migration Act, and that information is available in the notification letter that the client will have. If you're helping a client with that process and you're unsure, please just refer them for advice from us or another legal service. Some other ways to apply, there are ways other than online for people who may not be able to use that system. People can apply on a paper form. They can provide particular information by email or in a letter. Those ways of applying need to meet certain legal requirements in order to be accepted as valid review applications. So that's a bit trickier, and that's why we strongly recommend using the online form or the paper form. Someone can also go to the ART registry on Clarence Street in the city in Sydney to get assistance with applying. It's really important that you include your contact details, particularly an email address, as this is the form of communication that the ART strongly prefers, and they will use at all times unless your client does not have an email address. So we'd recommend, if they don't have one, that you create one to use for the application and review process. If you have a representative, you can provide those details. All applicants for review need to be included in the application, and the form will prompt you to include, or the client to include, this information. So for example, if it's mum, dad, and 2 kids, they all need to be included in that application. There is an option for the client to provide a copy of their decision record and their notification letter. This is not mandatory. The application for review will still be valid even if they don't do this. So it's really up to them. If it's particularly difficult for the person to do that within the time limit, the most important thing is just to help them get that in, even if it's not with the decision and the notification. Time limits, if I'll speak about that now, are very, very important. They're not flexible whatsoever. They're here on the slide. So the first line says in the community. By that, I mean someone who is living with a visa as a lawful non-citizen in the community. They have 28 days to apply for review at the ART. As I said before, someone in detention, in immigration detention, has 14 days to apply for review. Please always review the notification letter that a person has received. That will always tell you and tell the client how much time they have. There are additional working days if that letter was posted to the client. So that will provide them with 7 working days, as well as, for example, that 28 days that they already get. So it's really important to check the notification letter, firstly for what the date at the top of the letter, and then for how many days, depending on the transmission method. Again, if you're unsure about that, it's always important to just refer that person for legal advice as soon as possible, so that we can have a look at the letter and make sure the client's within time and help them to apply. The tribunal doesn't have the power to hear an application for review of a protection visa refusal that is submitted outside of these timeframes. They can only make a decision that they don't have jurisdiction to review the application. So it's really important that the person applies within time. It doesn't even matter if it's 1 day late as opposed to 30 days late. So it's important to go by those prescribed time limits. Lastly, for this slide, I just wanted to mention fees and costs. There is no fee to apply for review of a decision of the kind that we're talking about today. So applications to the ART for other types of review can attract a fee to apply, such as decisions to refuse other visas or decisions that were based on character. We've heard countless times from support workers, caseworkers, that their client was advised by a friend or maybe a dodgy migration agent that applying to the ART for this kind of decision does require a fee. They might have been told that that fee was a few $1,000s. And so in those circumstances, clients just didn't apply and then they missed that opportunity. So just to confirm, there is no fee to apply. However, as I've noted on this slide, if the review is unsuccessful, the person does have to pay a fee of $2,151 at present. That amount might increase. And that is to be paid within 7 days of the person receiving that invoice. And so that, just to clarify, that would only be if the review is unsuccessful. Thanks, Natalie. I've just popped a couple of examples in here of where to look on a notification letter in terms of figuring out what the time limit is. What I've circled there is transmission method. That will be included on the first page of the letter usually. And it will tell you whether that letter, for example, was sent by post or sent by email, and that will help you to determine what the time limit should be. And I've underlined there that as they've said, you know, this is an old AAT letter, by the way, but the wording will be the same. So they've said here that because it was sent by email, there'll be a period of 28 days commencing on the day you are taken to have received this letter, and then they clarify what they mean by that. So the letter will always contain that information. And on the next slide, I've just included an example of where someone was taken to have received a letter sent by post 7 working days after the date of the notice. Briefly, I'll just discuss what happens with a bridging visa while someone's at review. So there are a few different scenarios, the most common being the first one. So you'll normally be helping applicants who were automatically granted a bridging visa when they applied for a protection visa. So their bridging visa will continue to be in effect until a decision is made by the ART. 35 days after that decision is made, their bridging visa will cease unless another event occurs, such as the person applies to the Federal Circuit and Family Court for judicial review of that decision. And that means that if the client has access to Medicare, this will continue while they're at the ART and waiting for a hearing. Usually at some point during this process, because it is so long and drawn out, their Medicare card will cease and they will need to ask the tribunal at this stage for a letter confirming their status as an ART review applicant that they then provide to Medicare to renew their Medicare access. We get lots of questions from caseworkers and support workers about this. And the tribunal is very familiar with this issue. They will provide letters, in our experience, very quickly to clients who need that for the purposes of renewing Medicare. So as I've put down the bottom of the slide there, just to email the ART reviews inbox to provide the client's case number, the client's name, and to request a letter confirming their status as an ART review applicant. Obviously, if they are having issues with this, they can be referred for legal advice and we can help them to figure out what's going on there and to try and get that letter so they can renew their Medicare access. But to clarify, we don't help, unfortunately, with the Medicare part of things, and that's where you'd probably come in as case and support workers. If your client is in detention, so that's that second scenario there, they obviously don't have a visa, and so if they apply for review at the tribunal, they won't be given a bridging visa because of this. They will remain in detention throughout this process. Separately, of course, if they haven't had a visa cancelled, they're in detention for other reasons, they can always try and apply for a bridging visa, but that's obviously subject to particular criteria and is separate to this presentation. If you've got a client in that situation, you can ask them to contact legal aid or other services for advice. In rare cases, I've included this, it's rare, but I'll talk about it. An applicant might hold a bridging visa for other reasons and it has an expiry date. It might not be connected to their protection visa application. This might be the case if, for example, they had to get permission from the minister to apply for a protection visa, or maybe their matter was remitted from a court and they've applied to the court outside of the deadline. In those circumstances, the person may need to keep applying for shorter term bridging visas during the review process, but you will largely be dealing with people who will just have a bridging visa that continues to be valid throughout the process. So I'll go through the stages of the review process now. The first stage is obviously to apply for review, as we discussed earlier. So I've just noted there the importance of looking at time limits and providing correct contact details that the tribunal can use to contact you, and also providing representative details if the person has a representative at the time of applying. These can obviously be provided later on as well. The second stage is, I guess, a fairly long one, which is waiting for the hearing. It's generally 2 to 3 years unless you are prioritized. Clients in detention are generally prioritized, as well as clients in custody, and also those who've been remitted from a court. Usually for those applicants, they'll get a hearing hopefully within a year. That's not a solid deadline in any way. It's an estimation based on our experience. Otherwise, if you don't fall within those categories, you're waiting for a few years, unfortunately, at this stage for a hearing. It's still really important to make sure that you're telling your clients to consistently check their emails, or if they've elected another way to be contacted, checking that, and updating the tribunal if any of these contact details change. If the client doesn't do that, the tribunal will just continue to contact them using the contact details they've been provided. And if anything is missed because of that, unfortunately, nothing usually can be done about that. So if your client tells you they've got a new email address, it's really important for them to immediately tell the tribunal about this. They can do so by calling the tribunal, emailing the tribunal, or going to the registry in person. While they're waiting for the hearing, there's a few things that we'd strongly recommend that clients do. They can request a copy of their file from the tribunal by making a request via the tribunal's web form or using a paper form. Both of them are available via the tribunal website, which I mentioned before has a lot of really helpful resources for clients. The tribunal can provide the client only with what the client has given to them and what they have given to the client. Outside of that, the client really should also get a copy of their protection visa file. That can be done a couple of ways, but we'd recommend that the quicker way is to do this under Section 362 of the Migration Act. And what they're requesting is a copy of all written material given to the tribunal by the department. This can be done using a Department of Home Affairs web form that we will share in the chat. It's an alternative to doing a formal application under the Freedom of Information Act that, as many of you probably know, can take quite a while. So through the department, the tribunal will, as I mentioned already, they'll have a copy of the statements, submissions, applications the clients made for protection. If there is new information about your client's protection claims, or if they have new claims that they want to provide to the tribunal, they can do this at any point usually up to 7 days before the hearing. Or in exceptional circumstances at the hearing if something is extremely new. We encourage people to provide updated information about existing claims or to provide any new claims they might have. They can do this in a few different ways. They can prepare a statement or a letter. They can provide a statutory declaration. They can provide country information reports, newspaper articles, certified copies of documents they've obtained from their home country with translations if that's needed. Legal aid and other legal services can absolutely help with this. It can be quite a complex process. It's really important that the information is consistent with what's already been provided to the department and other decision-making bodies. And if the information or claim could have been provided earlier, this delay must be explained by the client. The law says that the tribunal will draw a negative inference about the credibility of new claims if the applicant does not provide this explanation, and if it's not a reasonable explanation as to why the claim wasn't raised earlier in the process. This doesn't apply in situations where the claim or evidence couldn't have been provided earlier. One example is, for example, if the applicant experienced domestic and family violence, and this gave rise to new fears returning to their home country, and this happened after the department's decision. There's no way they could have raised that earlier. And so in that case, the tribunal obviously wouldn't require an explanation as to any delay. As I said, this process is absolutely something we can assist with. So please refer anyone to our service or to other services if your client mentions to you that they might have new claims or new information. As I said, this has to be given to the tribunal no later than 7 days before the hearing. So in terms of a referral for legal assistance, the sooner the better. If a client's circumstances change outside of this, they also need to tell the tribunal. So as I mentioned, new contact details, if they've married someone or if there's been a separation or divorce, if there's been domestic and family violence resulting in a change to the family unit, if they've given birth to a new child, the tribunal needs to know about these changes because it can affect their application for review. So that's really important to tell the tribunal. They can do that again in a few different ways depending on what the change is. For some changes like contact details, there's a form on the tribunal website that people can access. In other circumstances, you could send an email or even refer the person for advice, and we could help them to prepare some kind of letter or submission about these changes for the tribunal. Usually it's difficult for a client who is waiting for a hearing to ask for that to be expedited. The tribunal's policies on expedited hearings state that generally that only applies if a person has been refused a visa because they didn't meet a particular requirement and they can objectively prove that they actually do meet that requirement. That doesn't really apply, unfortunately, in the context of protection visa refusals. It's more applicable in other visa reviews. However, if your client has come to you and they're very distressed and the delay is clearly having a significant impact on them, you can still refer them for legal advice, and we can talk to them about the likely time frame for a hearing, and we can always see if we can talk to the tribunal about the possibility of an expedited hearing. But unfortunately, in most cases, people are waiting about 2 to 3 years at the moment. So shortly before the hearing, the applicant will receive an invitation to attend the hearing. They'll receive this using probably email, and so it's very important they're checking their emails regularly. They'll be required to complete a hearing response form that includes questions about things like who will be attending the hearing, whether they need an interpreter or other assistance, whether they want the tribunal to contact any witnesses. We generally encourage people to complete the form and provide it to the tribunal as soon as possible. And this is something that you could also help your client with. The form mentions where you need to send it, which is by email back to the tribunal, or of course, someone can choose to print it out and give it to the registry in person. By now, the client should have their protection visa file and should start looking through it if they haven't already, particularly reviewing their protection visa application and any statement they may have prepared about their fears returning to their home country. For many of our clients, these documents were prepared years ago, and it can be really difficult to try and remember the details you provided in an application that you made that long ago. The tribunal will be asking lots of questions about the person's claims at the hearing, and if the applicant provides answers that are inconsistent with what's contained in those documents, this can result in the tribunal making a negative inference about their overall credibility. So it is really important that the person looks back through what they've said to the Department of Home Affairs and to other bodies, such as if they went to court or if they've already been to the IAA or the tribunal before. If by this stage, maybe the person has only come to you now with this invitation to attend a hearing, it's really important that you refer them for advice and also direct them to where they can request a copy of their file. And perhaps you could help them to make that request with priority, but we're also really happy to help clients to do that so that they can try and get those documents as soon as possible before the hearing. Alternatively, we can help clients to potentially ask for an adjournment of their hearing. The tribunal does not need to approve a request to adjourn a hearing. The client would have to have quite a good reason for doing that and for not having their file a few months before the hearing, but it does happen, and the tribunal can adjourn a hearing in some cases. So it's worth trying if your client is in that situation. If an applicant wants to have a witness or witnesses at their hearing, they need to ensure that they're getting statements from those witnesses that they provide to the tribunal, and that assists the tribunal to understand what the role of the witness is. That might be maybe a family member or a friend. someone like that, or we've seen people who ask their treating psychologist or caseworker or support worker to attend the hearing as a witness. Alternatively, someone can attend the witness as the hearing as a support person. Generally, support people don't participate in the hearing, but they are there just to obviously provide support for the applicant. And again, that needs to be told to the tribunal, ideally prior to the hearing taking place. The last stage is that the person attends their hearing. The tribunal is required to conduct a hearing with the protection visa applicant before making their decision, unless their decision can be made on the papers or without a hearing, and it's going to be a wholly positive decision for the applicant. So in other words, unless the tribunal has decided that the evidence before them is so strong that they can make a decision to remit the application without a hearing, to remit to the department and allow the person to be granted a protection visa, then they will have a hearing for that person. The tribunal, importantly, can dismiss an application if the applicant does not attend their hearing. If your client receives a dismissal due to non-appearance, it's really important that you refer them for legal advice immediately, as they do have a short window of opportunity to request reinstatement of their application. But that's within 28 days of receiving notice of the dismissal. So there is a fairly short window of time to do that. Otherwise, the tribunal has the power to, as I said, make a decision to dismiss that application, unfortunately. Most of the clients you'll be speaking with will have gone through some kind of interview process about their protection claims before, probably with the Department of Home Affairs. The tribunal hearing is a very similar process. It involves a tribunal member, but they ask very similar questions. So they'll ask the client questions about themselves, about their family, about their protection claims, and about any new information or claims that they may have provided to the tribunal. The tribunal is required to put adverse information to the applicant. In other words, information that could form the reason or part of the reason to affirm the decision under review. And they need to give the applicant an opportunity to comment on this adverse information. An applicant, as I mentioned, can request an interpreter for their hearing, and we encourage people to do so even if they're fairly confident in English, just to ensure that they fully understand all questions that are asked and they can provide detailed answers in their own language. They don't always need to use the interpreter. It might just be for some questions, but it's better to have someone there than not in a lot of cases. As I mentioned, they can also request any accessibility supports they may need. And if on the day of the hearing, these supports aren't there, the person does have the right to ask that the hearing is adjourned if there needs to be further time given to arrange those supports, because obviously they're very important to allow the person to participate properly and fairly in their hearing. Sorry, questions before we move on?
Yeah, is that all right?
Yeah, that's fine.
All right, so just on the slide we're currently on, I guess a couple of questions. Firstly, on that issue around preparing evidence, is that something you as a lawyer help people to gather the evidence, or would you be relying on the support workers and services?
No, absolutely, we do that. We can, as I mentioned, help a client to prepare a statement or declaration about their new claims or new evidence. We can talk to them about what evidence might be helpful for them. We can review that evidence before it's given to the tribunal and give the client advice about whether it's helpful. And then separately, if we're representing the client, we can also prepare, for example, submissions about these new claims and evidence or about new country information, and we can gather supporting information for that as well. So that's absolutely what we can do.
Great, thank you. And one other thing, can you please clarify did you say that the ART can dismiss a matter without a hearing if they felt that the case was too weak based on the files that they have?
No, sorry. So it's the contrary. It's they can only make a decision without a hearing if it's going to be what they've termed as a wholly positive decision. So in other words, if they look at the documents before them, and this is really rare, and they say the evidence is so strong that we feel we can make a positive decision without a hearing, we will do that, and otherwise we will hold a hearing. They cannot decide that a case is too weak and dismiss it without holding a hearing. However, if they do schedule a hearing and the applicant does not attend, and does not request reinstatement, then they can dismiss the application for non-appearance. I hope that clarifies things.
Thank you. All right. There are another couple of questions, but I think we'll come to those at the end, if
Sure.
that's okay.
That's fine. Yep.
Did you want to do some polls before we move on? Would that be appropriate? Checking people's understanding?
Yep.
Do the polls now?
The quiz, you mean?
Yeah.
Yes, sure.
All right. So everyone, hopefully you can see these polls. I'm just going to launch them and then we'll have a chat about the results. So hopefully you can see that on your screen there. So I'll just read them out. So there's 3 questions. The first one is, how long does a person have to apply to the ART for review of their protection visa refusal if they have received their refusal letter by email? 14 days, 28 days, or 3 days? I think people are answering though. Everyone's quicker than me. So the second one I'll read out for you. What about if that same person was in immigration detention? What was the relevant time period to apply for a review? They can't apply because they're in detention. They have 28 days still or 14 days. And number 3, how much does it cost to apply for review to the ART? And there've been a few questions about this cost issue. So I think we will have a chat about that.
Sure.
Just a few people still answering. And we will share the results of these in a second. Give people another few seconds. Okay, I'm going to end the poll now and we'll have a chat about it. And I'll share the results. So hopefully you can see on the screen there. Hannah, can you see that?
I can see that. And yep,
Excellent.
It looks like for every question, the majority of people got it right. So well done, everyone, for listening to a seminar during lunchtime. I'm impressed. Yes, that's right. So for question 1, a person generally has 28 days to apply to the tribunal for review of a protection visa refusal of the kind we're talking about today. Because that letter was received by email, they don't get any extra working days. Number 2, immigration detention means that they instead have 14 days to apply for review. And it costs nothing to apply for review at the ART. Some people, a small number of people answered the second option, which is the fee of 2151. That does apply if the person is unsuccessful, but to apply for review, it's free for this kind of decision. And maybe that leads into those couple of questions about fees.
So a couple of questions, I think, around the first one. I think that was clear. Someone was interested in why there was a difference in the number of days to apply if you're in detention.
It's a good question. I think the review process generally for people in detention, and this isn't just for protection visa refusals, is quite, it's conducted quite quickly and efficiently because the person is in detention. And so I think for a long time it's been that they've had less time to apply, less waiting time for a hearing, and then a decision is usually made fairly quickly. That's, I think, the logic behind giving people a shorter amount of time in detention. But I appreciate that for many people in detention, it can actually be more difficult to access legal advice and support from yourselves within that shorter time frame. We're very glad, we're very welcoming of the change from 7 to 14 days. Yeah,
for sure. And that the 14 days or 28 days we're talking about is just to put in your application. That's not to gather the evidence part that you were talking about before.
That's any time up to 7 days before the hearing.
You can provide that evidence. Yeah. And the costs, I don't know if you're going to talk about this later, but if somebody is unable to pay that cost, if they can't afford it or in financial hardship.
Good question.
What are the options?
The fee isn't likely to be enforced, usually because the person is probably quite clearly in financial hardship. However, if the debt isn't paid, that may become a non-issue, but it will remain as a debt to the Commonwealth. So what that means is that if the person, for example, decided after this process being unsuccessful to return home, and then in future wanted to make another visa application to come to Australia, one of the criteria may be that they have no debt to the Commonwealth. That's, for example, a criteria for a visitor visa. So they'd need to clear any of that debt before being eligible to be granted that visa. So it can affect people in future, even if it might not be enforced immediately.
Okay. Before I close the poll while we're on this, can you just clarify again, is it 14, when you talk about 14 days and 28 days, is that
Yep.
days in general or business days?
Days, days in general,
days.
so includes
Okay.
weekends. Yeah, so it's when it's working days, that's when you have to think about, is it a weekend, is it a public holiday?
Okay.
Yep.
Thank you. All right. I think we are done with the polls. Well done, everyone. That was great.
Yeah, awesome work. Okay, in the interest of time,
Yep.
I will very briefly move through this slide because this could be a whole separate presentation. If someone receives a remittal, that's a win. The directions that are given to the department by the tribunal are usually something along the lines of the person is owed protection under the Migration Act, or the person meets the secondary applicant requirements as a member of the main applicant's family unit, something like that. What happens practically then is that the matter is remitted or sent back to the Department of Home Affairs, who then conduct mandatory health and character checks. So I wouldn't say that it guarantees that the person will be granted a visa, and the tribunal doesn't have power to grant the visa. But generally, once that remittal happens, as long as the person meets health and character requirements, they will be granted the visa by the department. That process can take a little while, particularly if the person has a criminal history of any kind and they have to go through character processes. Otherwise, a decision might be affirmed. That means, in practicality, the decision of the department stands. The tribunal may have provided very different reasons for that decision, but it's the same outcome. If that happens, the person has the option to go to judicial review, which I'll speak about in a moment. But the only other decision that could occur is a dismissal decision, as I discussed earlier. Judicial review is something that our team works in, and we help a lot of clients with judicial review processes. So if you're talking to a client who's received a negative tribunal decision, please refer them for advice from us. We can represent people at, as I mentioned, the Federal Circuit Court or the Federal Court or the High Court if there are reasonable prospects of success. Judicial review is very different to merits review. So the court cannot look at a person's claims and decide, for example, whether the court thinks they face a real risk of persecution or significant harm. They can't consider new evidence, new claims, or new country information. The court's role is simply to assess whether the tribunal made a legal error in their decision. This is a very narrow form of review. It's very different to the tribunal process. An applicant for judicial review will have to pay an application fee, which is a few $1,000s unless they can get a reduction or an exemption on the basis of financial hardship or other reasons. If they're in detention, for example, they can get an exemption from the application fee. However, if they're unsuccessful in their review at the court, a cost order in the amount of usually about several $1,000s will be made against them. And as I mentioned before, with the tribunal fee, these costs will become a debt against their name if they're not paid. Please refer anyone looking to apply for judicial review or who may have already applied and hasn't received advice to legal aid for further advice and possible assistance. Very briefly, a few other options would be ministerial intervention if the person meets the requirements for that. Being successful in ministerial intervention is rare. It's difficult. For the tribunal to for the minister to substitute a more favourable decision under Section 351 of the Migration Act, which is an example of the minister intervening, there need to be very compelling circumstances. For an alternative form of intervention by the minister under Section 48B, there needs to be new compelling information or claims that couldn't have been provided earlier or significantly changed country conditions. RACS, I'll just give them a quick plug, have some very useful fact sheets about ministerial intervention available on their website. Legal Aid, RACS and I can provide some advice and assistance for ministerial intervention, but generally we can only assist people if the matter is very compelling and if we have capacity. As I mentioned, the success rates are unfortunately really low. Another option for people is to maybe consider if they're eligible for another kind of visa, but it's important to remember that because they've now been refused a visa in Australia, they're limited to only a few alternative visa options. And for people such as our fast track cohort that came by boat to Australia, there's another additional bar that applies to them that means they can really only apply for a protection visa once or a bridging visa unless the minister intervenes. So for a lot of people, another visa application is simply not an option, unfortunately, but we are happy to talk to people and give them some advice about this if they think that they might be eligible for another visa.
Thanks, Hannah. Sorry, quickly on that first point, if a decision is remitted, does the person get their visa straight away or do they have to go back for more interviews with the department?
Not more interviews necessarily. So a remittal means that the tribunal is giving directions to the department about the person's the person meeting criteria for grant of protection visa, but the tribunal is not granting the visa. The tribunal is simply telling the department, this person, for example, is a refugee. The department then has to undertake other checks, such as health checks and character checks. And if the applicant meets those checks, then they will be granted the visa. If they don't, then they may not. We'll move on now to the case studies. These are just, again, to sort of test people's knowledge. They're not particularly complex. This is client A, who's come to see you with a letter from the department notifying him that his protection visa has unfortunately been refused. He's very upset and distressed. He tells you that he needs your help. He wants to apply to go to the court immediately to challenge this decision. You check the letter and it was dated 30 days ago, but the client tells you he got it in the post. What can you tell the client about what they may be able to do?
All right. We'll just go to the answer now.
Yeah,
I think, just
in the interest of
time.
Yeah, yep. So I'm sure all of you were thinking. The first thing I do is check the notification letter to confirm that the transmission method was indeed post. If so, you can show the client the parts of the letter that confirm that they have 28 days plus those 7 working days, and you can help them to calculate what date the last day would be. If the client has those days, it sounds like they're still within time to apply for review. You'd let them know that they're applying to the court, to the tribunal, and not to the court. And then you'd refer them straight away for legal advice and assistance to apply. Hopefully client A can get that application in time. Client B has sent you a forwarded email from the tribunal. They have an invitation to attend a hearing, and they've been asked to complete a hearing response form. The client tells you that she has separated from her husband last year, which you were aware of due to domestic and family violence, but she's now realizing that she is scared to return home for other reasons other than what she's already told the department, because he actually has family members that live there, and they've been sending her threatening messages. She asked for your help because she wants to tell the tribunal about these new claims. She also tells you that her husband has access to this email address and she doesn't want to use it anymore. So what would you help the client to do in this scenario? You would help them to complete the hearing response form. She might want a support person at the hearing. She might want a witness or two. You can help her to respond, and you can also help her to advise the tribunal immediately about the changes to her contact details. Maybe she's moved address as well, and it sounds like she wants to use a new email address. So you can fill in what's called an MR6 form available on the tribunal website to tell the tribunal about that, or you could even call the tribunal with her to tell them about these important changes to her situation. And lastly, you would refer the client for advice about their new claims and how to tell the tribunal about those claims, as well as telling the tribunal about the changes to her family unit, because the tribunal has the power to separate review applications. Even though this client would have applied probably for review of her joint application with her former partner and her children, if she has any, the tribunal can separately consider now her ex-partner's application. He will not be required to attend the same hearing as her. His claims will be considered separately to her, and the children can be included in her application. So it's really important to be telling the tribunal about these changes as soon as possible, because it can have a big impact on their review process. Lastly, these are some contact details for ourselves, Legal Aid, IARC and RACS, who are also free legal service providers and do help with protection visa refusals at the Administrative Review Tribunal. If you don't take a screenshot of these, we can send the details around. As you can see, we have both a phone number and an email address. Sorry, that legal aid number should have option 1 in brackets because there are 2 options to select when you call the number. We can let people know that when we send an email out. And IARC has a phone number, an email, and a web form, I believe, and RACS have a phone number and an email as well. So please encourage your clients to reach out for advice from us. We only have a couple of minutes, but I'll try and answer a few questions in that time if there have been any more that have come through. Oh, I think we did have a couple before the webinar. I'll just briefly address those. There was a question about whether during this process people can access Centrelink if their children are Australian citizens. Unfortunately, there are residence rules that apply to all applications for Centrelink payments, and most of the time it limits access to payments such as like the family tax benefit, for example, to people who are residents of Australia, not to people on bridging visas. Only in very particular circumstances could they access payments like the family tax benefit. We don't give we don't give advice beyond that. So I'd recommend if you've got a client in that situation that you speak to Centrelink. But it's unfortunately likely that they may only be eligible for the special benefit payment. There was another question about how to know if someone is at the tribunal or whether, for example, they might be at ministerial intervention stage instead. The best way to do that is to have a look through the client's emails with them to see if there's any correspondence from the tribunal. They would have got a few emails just after they applied, confirming the application, acknowledging the application. If there's nothing, you can call the tribunal with them or email the tribunal with the client's details to see whether there's an application on foot for them. If the answer to all of those is no, then it sounds like they probably don't have an application with ART. And if that is concerning, if they think that they did apply or they want advice about that, please refer them to one of our services. Or you can do a Vivo check with a client to confirm that they have a bridging visa. This doesn't necessarily mean, though, that they are definitely at the tribunal stage. So again, if you're unsure, just refer for advice. And lastly, someone asked about whether we give advice about bridging visas. That really depends on the situation. If you're unsure, please contact us and we can assist if it fits within guidelines. For some bridging visas, we don't give advice, but for other situations we can. I'm sorry, that's not a very clear answer, but it really does depend on individual circumstances.
Thanks very much, Hannah. There are another few questions. Perfect timing, by the way. We're only a minute or two over. So if people do need to leave, thank you very much for joining us today. I hope you all learned something new and useful for the people that you support. Last week, we also did another webinar with one of Hannah's colleagues about some changes to the law for people on temporary visas who've experienced domestic and family violence. So that recording is on the Legal Aid YouTube channel, and you will all get an email, I think it's tomorrow, which will have some of the links we've been talking about today, as well as the link to the recorded webinar. If people have time, if you've asked a question, we'll try and answer some of those quickly now, if that's all right. I think you've done a good job answering the questions. So just on the slide that we've got on now with the different services, I guess what you've said is Legal Aid, your team at Legal Aid, IARC and RACS do have some similar roles, but it just depends on your capacity and the exact circumstances.
That's right. Yeah, but I just really want people to know that there are options and that even if, for example, one of our services doesn't have capacity, there are other ways for your client to get legal advice. We all assist with this process.
And someone's just commented maybe if the times are still the same for IARC advice, but I guess you just have to call that number to find out. Sorry.
That's right. Yeah.
I also tried to find, while you were talking, Hannah, the link to the webinar you mentioned that IARC is running on Thursday.
Yeah, I believe it might be on the IAC website, or if someone from IAC is in the
I
webinar
haven't been able
still.
to find it, but we will try and link to that as well
Yeah,
if we can in the
I've
email
got a
you
link
get.
I can provide. Yeah, sure.
Okay, yep, we'll
Yeah.
try and include that for people. Okay, there's a few questions. Sorry. Just coming back to the hearing, someone's asked if being a witness and a support person is the same role or function, or if they can be two different people. They're quite different, I understand.
A witness and
Yeah.
support person,
Yeah.
is that? Yeah, different, very different functions. A witness is providing evidence that to assist the tribunal in making their decision. So that could be evidence from a family member, a friend, some kind of professional, or a support person, alternatively, is simply there, as the name suggests, to provide support. They don't participate in the hearing. The tribunal won't ask them questions. The tribunal will usually allow a support person to be there just so that the applicant has that person there. So yeah, quite different functions.
Thanks. And someone's asked if you can repeat the average waiting time from submitting an application to the ART to the hearing.
Yeah, sure. So the waiting time for people in the community is at the moment usually around 2 to 3 years. If the person's in detention, it's shorter. I'd say maybe 6 months to a year. Yep, those are all very generalized timeframes. It can be different for everyone.
Yeah. And also somebody's just put in the chat that there's also an option for, I think, face-to-face advice that RACS provides in Auburn, but I guess call that number to find out more details about that.
Yeah, that's true. That's
Yeah.
true. RACS does, have an Auburn
So
outreach.
thank you
Yeah,
for that.
that's a good option.
Someone's asked, how can I request to get a client's file? I'm not sure what.
So there are a couple of ways that I mentioned earlier. We could even, that's okay. So there's, you can contact the tribunal to get a copy of only what you have sent to the tribunal or what the tribunal has sent to you. So that's usually pretty limited. That's just by going to the tribunal website and either filling out their web form or completing a paper form. It's usually a pretty quick turnaround for that. Or you can submit a request using that web link that Natalie has sent to everyone. It's on the Home Affairs website, and it is a request to get a copy of the file that the department gave to the tribunal. So that's your protection visa file. It's a quicker process than FOI. That's the third option, is a freedom of information, a formal freedom of information request that can take a few months, but that is another option if someone wants to do that. And that's just writing to the freedom of information department or team at the department to request a copy of your protection visa file.
And just a comment, someone said they've seen you can make arrangements for, I guess, a payment plan for that if you're unsuccessful.
Yeah, that's true.
Yeah,
You can
so
speak
that's
to the
another
tribunal about
option
that.
as
I'll
well.
just
So
also
thank you
add
for
with
that.
the requests for your file. For some people, they may have made another application for a visa, such as a visitor visa or a student visa to enter Australia. The tribunal will sometimes have that documentation as well and may ask questions about it. So if you're helping a client who's got a couple of visas in their history, it's best to be safe and help them to request a copy of all of those files, and those other documents outside of the protection visa file would need to be done through freedom of information. We can help with that, and so can the other services.
All right. Well, thank you, Hannah. I think that covers everything. As I mentioned, you will get a link to a survey and also an email that will be sent out tomorrow. So that will have some of the links, including to the Legal Aid New South Wales web page for the immigration team, which includes some information as well as links to, I think, RACS and IARC and the phone numbers to call. So thank you, everyone,
Great.
for joining us today.
Thanks, everyone.
We look forward to getting your feedback. Thanks so much, Hannah, for your time and expertise.
Thanks, Natalie.
See you again.
Bye.
Thank you, everyone. Bye.